WordPress Accessibility Day 2023. How to address accessibility and privacy to help avoid fines and lawsuits. With speakers Donata Stroink-Skillrud, President, Termageddon, and Hans Skillrud, co-founder and vice president at Termageddon LLC. This presentation was recorded on September 27th, 2023.
And my name is Laura Adamonis, and I am a website designer with my own agency. I volunteer as a content creator for the training team at learn.wordpress.org. I live in North Carolina, but I'm originally from Chicago. I have a passion for UX, UI, and accessibility. Thank you for joining us for how to address accessibility and privacy to help avoid fines and lawsuits with Donata Stroink-Skillrud and Hans Skillrud. Donata Esquire, CIPP, is an attorney licensed in Illinois and a certified information privacy professional. Donata is also the president and legal engineer behind Termageddon and is responsible for the policy questions, text, and keeping clients' policies up to date with changing legislation. Donata is the chair of the American Bar Association's e-Privacy Committee, member of the ABA's Cybersecurity Legal Task Force, and member of the Science and Technology Section Council. Donata is also a fellow of the American Bar Foundation. Hans ran a 12-person web design agency for about a decade prior to selling that business and running Termageddon full-time with his wife. At Termageddon, Hans oversees partnership and business development opportunities and spends his time providing education to website owners about the importance of website policies. Outside of Termageddon, Hans spends his free time metal detecting, interesting, working with audio,
Arduinos. Nice.
I'm like brain fart there. Working on his garden and doing fun activities outside. They are fellow Chicagoans with a love of pizza. So I had to ask the big question, thin or thick crust, and they love it all. Their favorite for thin crust is Pisano's, and their favorite for thick crust is Pequod's. Please feel free to add your questions in the Zoom Q&A section, and we'll answer them at the end of the session. Use the chat to connect with others attendees. Let's have a warm welcome for Donata and Hans.
Thank you so much, Laura, and thank you everybody for joining us for our talk on privacy and accessibility.
And I'd imagine everyone here couldn't be more excited to talk about privacy policies and whatnot, right? I would assume everyone's super excited.
I'm excited.
Hopefully, if there's still people at the end of this presentation, like at least one person, then we've done our job. So.
Right, definitely. So we're gonna share our screen now because we do have a presentation, but definitely put your questions in the chat. And let us know if you have any questions. We'll be answering those at the end. So like Laura said, we're gonna talk about how to address accessibility and privacy to help avoid fines and lawsuits. So the first thing we wanted to say is, because we are going to be talking about laws, rules, and regulations, is that the information that we talk about today is for informational purposes only and is not to be considered legal advice. If you are looking for legal advice, make sure to reach out to an attorney in your area for that.
And this does include the Q&A session. We highly encourage everyone, if you have any questions about cookie policies, cookie consents, or the intersection between accessibility and privacy or policies, please feel free to ask any questions. Just remember that everything we provide today is for informational purposes only.
Exactly. So we were already introduced, so I don't think we have to go through this again. And I think we can just jump right in.
Well, we can do a summary. This is a photo of Donata and a photo of myself. And Donata's bio basically outlines that she's the smart one, and I am more so the character in the group, I would say. So
very true. Okay. All right. So the things we're going to talk about today, we have a pretty packed agenda, and we're going to talk about how privacy and accessibility intersect, why they matter, who needs to follow these requirements, who needs to have a privacy policy and a cookie policy, and how to properly display those policies, as well as who needs a cookie consent banner and how to properly display it and what those should look like. We'll also talk about obtaining consent in an accessible way and why that matters, as well as examples of dark patterns. So basically things, what to do and what not to do. So we'll show you some examples, and then some final tips on meeting privacy and accessibility requirements, and then we'll go into the Q&A.
So a lot of you probably have an understanding of what accessibility is, but because we're coming more from a privacy expertise, we wanted to at least cover what privacy is. So privacy is generally defined as being left alone or the state of being free from observation by others. I will say, though, that privacy, I think, means different things to different people. But really what's happening here in the world is that we have governments protecting and regulating the personal information of their people. So what personal information is anything that can be used to identify an individual. That is personally identifiable information, otherwise known as PII. So governments around the world are creating regulations to protect people's PII so that website owners or companies can't just take that personal information and do whatever they want with it. You know, here in the States, we actually have a friend visiting from the UK over the last week. And the moment he got to America, he started getting about 30 spam calls a day. And that is an infringement on privacy, at least in many people's opinions. And that is what governments are trying to help regulate and prevent from happening.
Yeah, and privacy basically means that people can determine the level of interaction that they would like to have with a company online. So if I want to receive email marketing from a company, I can say, yes, I would like to receive it. Or I can say, no, I would not like to receive it. Or I would like to receive text messages from you, or maybe I don't want to do that. So it's the level of interaction that they would like to have with a company online.
And there's nothing wrong with collecting personal information. In fact, I always advocate that's a great thing. What we need to understand today as website owners is that we need to get consent first prior to collecting people's information, and also making sure our policies are up to date with accurate disclosures you're required to make under applicable laws.
Yeah, and what is accessibility? So accessibility is defined as the practice of making information, activities, and environment sensible, meaningful, and usable for as many people as possible. So it basically means that people can interact, comprehend, navigate, and contribute to the online world. And privacy and accessibility, even though they're two distinct concepts, they do intersect together to create a digital world that is open to everyone, regardless of their disability status or their privacy preferences. So accessibility can interact with privacy because it can make privacy-centric features compliant with privacy laws, because privacy laws do require accessibility. And privacy can make accessibility features usable without somebody needing to sacrifice their personal preferences on their privacy, meaning they don't have to sacrifice the level of interaction that they would like to have with companies online, and they don't have to sacrifice their privacy rights as well.
And we have a handful of examples to go through today to kind of really instill this concept into everyone's minds today.
Absolutely. So why do privacy and accessibility matter? So we have a couple of reasons as to why, but first, it's really the right thing to do. So presenting your website visitors with an accessible and privacy-conscious website is the right thing to do. So you should allow people to clearly see privacy information and make privacy-related selections to allow them to determine how they would like to interact with you and how. And then providing an accessible website, make sure that everyone can use the website without difficulty or frustration. So they both work together to make a better web. Second, it's actually good for business to care about privacy. So if you think about 10 years ago, privacy wasn't really a big deal. People didn't really look at privacy policies or look to see if somebody had a cookie consent banner. They didn't care if you tracked them via Google Analytics or Facebook Pixel, at least for most people. But that has changed. And that really changed with the Cambridge Analytica scandal, where Cambridge Analytica took the personal information of millions of Facebook users without their permission and used it to manipulate political advertisements. And that really brought privacy to the forefront of consumers' minds. They really realized, if I provide my information to a company, they can do pretty much anything with it, and there's nothing I can do about that. And that's where all these privacy laws and regulations really come from. But people are actually more concerned about their privacy than ever before, and they are willing to make decisions on who to do business with based on privacy practices. And there's a lot of studies that talk about this, but two that I wanted to highlight. 32% have switched companies because of privacy practices, meaning that they went from one company to another because of privacy concerns. And 7 in 10 Canadians refuse to provide data to a company over privacy concerns, meaning that 7 in 10 Canadians, for example, would not fill out a contact form if they don't feel comfortable or they don't receive sufficient information about what you will do with their PII. And accessible websites can also be a competitive advantage as well. So 75% of Americans with disabilities report using the internet on a daily basis. And the market that includes people with disabilities is estimated to control over $13 trillion in annual disposable income, which is huge for business, right? So if you have a website that allows these people to use your website to make purchases or subscribe to emails or whatever they want to do, you are opening yourself up to a larger market.
There's 2 more items too, and they kind of go hand in hand, which is avoiding fines and lawsuits. I'm sure throughout the WordPress Accessibility Day, this has been discussed, and sure enough, we're covering it as well. The fact is, though, there are privacy non-compliance fines. There are one-person marketing companies getting fined, 60,000 euros for changing the email address of one of their subscribers without their consent. And I think really what comes into play here is that I don't think a lot of people realize, I think a lot of people see in the news like Facebook getting fined billions of dollars for privacy issues. But what they don't see are small businesses, like one-person companies, even getting fined for non-compliance from a privacy standpoint. So fines and lawsuits, I mean, we have it listed here, but really the long story short is failure to comply with applicable accessibility laws and privacy laws can result in your business getting into financial trouble as well. So it's not only the right thing to do, but not doing it actually gets you in trouble. So it's like double whammy to stay focused on valuing this.
Yeah, so privacy law is currently enforced by data protection authorities and attorney generals. So the fines for non-compliance start at $2,500 per violation, meaning per website visitor whose privacy rights have been infringed upon. So let's say you have 100 website visitors from California and you don't have a compliant privacy policy, that fine is calculated as 2,500 times 100, which can add up really quickly. Yeah. But there are also proposed privacy bills that would allow consumers to sue businesses of any size, of any revenue, of any employee size directly for privacy law violations as well. So now we're seeing so many accessibility lawsuits, but we're probably going to see the same thing with privacy once these laws are passed.
Yeah, if I'm not mistaken, actually, lawsuits for accessibility came out of New York, and then sure enough, New York has 2 bills out right now. If any of them pass, it will enable any New Yorker to sue any website owner for collecting as little as an email address and a contact form without specific New York privacy law disclosures.
Yeah.
So yeah, it's good motivation. It's the right thing to do, though, is number 1.
So who needs to follow privacy requirements? So as Hans explained earlier, privacy laws govern the collection, use, and disclosure of personally identifiable information. So PII is any information that could identify somebody or any information related to an unidentified person. And examples of PII include names, emails, phone numbers, IP addresses, or physical addresses, such as the billing address. And those are commonly collected through contact forms, email newsletter subscription forms, e-commerce forms, analytics like Google Analytics, or advertising features like Facebook Pixel. And what's important to note here is that privacy laws apply as soon as that information is being collected. So you don't have to actually use it, you don't have to disclose it, you don't need to share it, and you don't need to sell it. The moment that that information is being collected, that's when privacy laws apply.
And just want to provide a little footnote of education here. We have so many business owners that say, well, I don't share any of the data I collect. And I like to always just make note of an example that's very common. If you have a contact form on your website contact page and someone submits an inquiry and you receive an email in your inbox with that person's contact details, you've not only collected their personal information like names and emails, but you've actually shared that data with your email service provider, whether it's G Suite, Gmail, Outlook, or any other third-party email service system you use. So sharing data, extremely common. What's not so common is selling data. So, but sharing data, very common, and that can be a required disclosure under certain privacy laws.
So you will need to follow privacy requirements if you collect PII. So if you're collecting like names, emails, phone numbers, or if you're, and if privacy laws and their requirements apply to you. So privacy laws do not apply to every single business out there, but they protect consumers and they don't protect businesses. So that means that they can apply to you regardless of whether you're located in the state or country that passed that law. And that's because of the broad nature of the internet, right? So people from anywhere could submit their personal information to your website. So to figure out what privacy laws apply to you, you should ask yourself some questions. So whose PII are you collecting online? Like who's submitting these forms? Who are you tracking online through cookies, pixels, analytics? So if you have those features on your website, who's coming onto your website and being tracked? Where are your customers located? Where do you do business, and where do you offer goods or services? So most privacy laws will apply to businesses regardless of their revenue or employee size. So they will apply to small businesses, and a lot of privacy laws actually apply to nonprofits as well. But some privacy laws will exempt smaller businesses. So it is important to first determine what laws apply to you.
That's right. And just to reiterate, because you have a website and you could collect inquiries from all over, it's good to remember privacy laws protect people. They don't care where your business is located. So,
Yeah.
and I know you just said it, but I'd just like to say
Thanks.
it louder. So,
So there are a lot of privacy laws that govern the collection of PII by websites. We won't go through each and every one of these because I don't want to bore you to death, but just a couple examples. So like the California Online Privacy and Protection Act, that applies to any business that collects the personal information of residents of California. So people from California could submit a form on your website, or you could collect their IP address or like Facebook Pixel. You need to comply with that law. Whereas other laws like Nevada Revised Statutes Chapter 603A, for that law to apply to you, you will need to collect the personal information of residents of Nevada, but you will also have to do business in that state. So as you can see, there are different factors to determine which privacy laws actually apply to you. And it's really funny because since creating these slides, there's a new privacy law that was passed, the Delaware Personal Data Protection Act, which we haven't had a chance to add to that. But I think that just kind of illustrates how frequently these change. So there's over 24 privacy bills proposed in the US. Countries such as the United Kingdom, Australia, and Canada are proposing reform to their privacy laws because of new technologies that create new privacy harms. So the laws have to keep up. So these things are constantly changing.
and really, I think the big takeaway there is, as a website owner, I used to copy and paste privacy policies whenever I needed them. And, I married a privacy attorney, so that obviously changed. But really the takeaway is, I think the era of copying and pasting legal docs is not only a terrible strategy upfront, because chances are you're not compliant with the actual laws that apply to you. But also it doesn't answer the question of how do you keep your policies up to date over time. So, and this isn't a sales pitch. I mean, obviously talk to your attorney. There are generators out there like Termageddon 2, but really the most important thing is understanding that you can't just have a privacy policy in this day and age. You have to have a strategy to keep it up to date over time.
Exactly. So who needs to follow accessibility requirements? So Title II of the ADA applies to all services, programs, and activities of state and local governments. So if you're part of state and local government, you obviously have to follow them. And Title III of the ADA applies to businesses open to the public. So there's a case that Gill versus Winn-Dixie Court that ruled that websites may constitute public accommodations and therefore be subject to the ADA. So those must be accessible. And although websites or apps are not explicitly stated in the law, the online world is increasingly being considered as a public accommodation, and there are a lot of cases that support that. In the EU, we have the EU Web Accessibility Directive and the European Accessibility Act, which requires public sector entities and private companies to provide accessible experiences for website visitors. The Accessible Canada Act applies to any organizations under federal jurisdiction, and the Australia Disability Discrimination Act prohibits private and public sectors from discriminating against people based on a disability. What's really interesting as a privacy lawyer that I've seen recently in all of the new privacy laws that have been proposed and passed is that they also state that your website features that are privacy focused must be accessible as well, meaning that your privacy policy must be accessible, your cookie consent banner must be accessible, and your cookie policy must be accessible as well. So it seems like the two worlds are merging much more than 10 years ago. Any new laws passed didn't really talk about accessibility, but they do now. So Hans, maybe you can explain who needs a privacy policy.
Sure. So a privacy policy helps explain your privacy practices and is usually created to comply with privacy laws. So it all kind of starts with what personal information you're collecting, what you're doing with that information. Like I collected to contact you, I collected for marketing or advertising. Some privacy laws require you to describe how you collect that information or who you may share it with, or if you sell it. Really what it comes down to is that a good privacy policy will help you. A good privacy policy is created if you know the laws that apply to you, because each privacy law lines out exactly what you're supposed to disclose. So your very first step is to find out the laws that apply to you. And then a privacy policy from there needs to include the disclosures required by those applicable laws. Your privacy must fit your actual business and privacy practices. So I think that's one of those concerns I have where people just copy and paste legal documents like I used to. Like I didn't actually read it. I don't know if they actually match my actual business and privacy practices. And most importantly, they need to stay up to date over time as legislation constantly changes in this space.
Yeah, and I think it's important here to note that all privacy laws require websites to have a comprehensive privacy policy. So if any of the privacy laws apply to you, you will need to have a privacy policy that makes those disclosures. And then who needs a cookie policy? So the cookie policy, its purpose is to inform users about what cookies you collect, why you collect them, and how individuals can exercise their privacy rights by changing their cookie preferences. So for example, how can people withdraw their consent to cookies that they have provided their consent to before, which is required by applicable legislation. So you will need a cookie policy, or you can also have a privacy policy that discusses cookies. If your website collects cookies, and if you need to comply with the privacy directive, EU's General Data Protection Regulation, UK's Data Protection Act, or Canada's PIPEDA, because all of these laws require businesses to inform consumers what cookies are on a website and how they can exercise their cookie choices.
And I'll also note, some of you may be like, well, what about CPRA or VCDPA? That is related to a notice that users are required to provide, website owners are required to provide if you sell the information you collect. So I think a lot of people are surprised to hear that a cookie consent banner is very different based on which law applies. A California banner is to opt out of the sale of the information, whereas a GDPR e-privacy directive banner for the EU is more about giving people choices and them being opted out by default, and they have to consent to being tracked for marketing purposes, for example.
And CPRA does not specifically require you to have a cookie consent banner or a cookie policy. They do require you to have a universal opt-out mechanism, and it just seems like everybody chose to have a cookie consent banner, and that's what's kind of became the standard, but it's not actually required by the law per se.
That's very
true. In that particular way.
Yeah, good call. Who's gonna take it? I'll take it.
Yeah.
So in summary, to meet the requirements of privacy laws, privacy-related policies must be posted conspicuously on a website, aka make your policy links easily accessible. So I'm sorry, I didn't mean that in summary. That's actually kind of the next topic of discussion, but a very clear requirement when providing policies on your website is that they're accessible. And we're not talking about, putting them in your footer and having a black background with super dark gray text. That is not conspicuous. Rather, you want it to stand out and make sure that anyone can see it from a mile away.
Right, exactly. So conspicuous is kind of a legal term, right? So what does conspicuous actually mean? So to be conspicuous, a privacy policy and a cookie policy, they must be displayed in a way that a reasonable person would notice it. So what does that mean? So first, the link to the privacy policy and the cookie policy should be posted on the footer of every page of the website, meaning that if I navigate from the homepage to the blog, it should still be on the footer. The link should contain the word privacy for privacy policy and cookie for cookie policy. So that means that a link that says policy is not sufficient to be conspicuous.
What about a link that says legal and then you're taken to a page that provides all the policies?
Also not conspicuous because it needs to include the word privacy.
Boom.
So if it does not include the word privacy, it is not conspicuous because people don't necessarily know what legal means. Like, does legal mean your VAT number and your company address? Does it mean your terms of service? Does it mean a contract? Does it mean your company formation documents?
Does it mean that's where the legal people go to read something?
Yeah,
on the
I mean,
website?
it could mean literally anything. So it does have to include the word privacy for privacy policy and cookie for cookie policy. The privacy policy and cookie policy should sit on separate pages. So do not combine a privacy policy and a terms of service. Multiple privacy laws say this. In addition, if you have people agree to a privacy policy and a terms of service at the same time, you actually cannot prove consent. It can also seem coercive. So there's been certain enforcement actions that said that it's coercive to make a user agree to privacy and terms at the same time, because the user feels like they are being subject to contractual requirements at the same time. So do not combine these two. Accessibility experts know this. Use contrasting type, font, or color from the surrounding text, if there is any, and use contrasting color of the link as compared to the footer. So basically make sure that it's easily visible. And any forms where PII is being submitted should contain a consent checkbox for individuals to agree to the privacy policy. The box should not be pre-checked, and it should be a separate box from an agreement to a terms of service if you do decide to have a terms of service agreement as well. Okay, so now we're going to go into my favorite part, which is examples. And what's really funny about this is that when you search for examples, it will take you 20 minutes to find all the bad ones and about 3 weeks to find all the good ones. So that kind of just illustrates how things work.
Yeah, and even in this first screenshot, I think this is a great example of clearly providing the text to the policies. However, they're not underlined, so people may not know they're actually links. So I would say that's an improvement for the first screenshot we've shown here with the light pink background and the completely black large bold font text.
But it is easily visible, right?
Yes.
You can clearly, it's a contrast. So you have the pink background, and then you have accessibility statement, privacy policy, code of conduct, and contact us, as well as social media links like Facebook, LinkedIn, Twitter, and YouTube, all in black. So you can very easily pinpoint where the policies are. And in the second example, you'll see there's a light gray background, and then there's privacy policy, terms and conditions, disclaimer, affiliate terms and conditions, and cookie policy. All of them are separated and they are in dark purple font. So they're very easily visible. They're not hidden.
All right, so then also it's important to understand that whenever someone's submitting their data, it is considered a best practice. And under some privacy laws, it's a legal requirement to ensure that people are checking a box to agree to your privacy policy and checking another box to agree to your terms. So as you'll see in this example, this website has a contact form asking for name, email, message, and then there are two check boxes. I agree to the privacy policy and I agree to the terms and conditions. Privacy policy is underlined, and so upon click, it would open in a new tab, the respective privacy policy, and the same with the terms and conditions. So the policies are clearly linked and underlined and visible. And also you'll notice the check boxes are unselected by default. This is very important from a privacy compliance standpoint. You need to capture consent the moment people agreed. So that is why those checkboxes are required fields, but you actually have to check them to be able to submit your data.
Yep, exactly. So in this next form, we have a traveler's form where people can book flights. So you'll see that they can book flights from Washington to somewhere else, and then you can click find deals, choose your departure date, things like that. And then it has a box that says receive our travel deals newsletter. Now, what's good about this box is that it's not pre-checked. However, it does not obtain proper consent. because it is not providing a privacy policy and it does not link to a privacy policy. So here, even though they're obtaining consent for their newsletter, which is great, they should also have another box that says, I agree to the privacy policy, because their data is being collected.
And we probably should have updated these slides to how not to display your website policies, but do you want to take this one?
Sure. So this is an example of the text of the privacy policy. So the first one says sale of your information. We do not sell your personal information. Please see the Your Rights section below for more information about exercising your privacy rights regarding sales of your personal information. Very common disclosure for people who need to comply with privacy laws that require them to disclose whether information is being sold. Now, in this first box, the font is very clearly contrasted. It's white, and then the background is white, and then the text itself is black. So it's very easy to see. The font is large, so most people can see it without having to actually zoom in or anything like that. Now, on the second box, we have another example of a privacy policy. So it says payment data, like cardholder last name, date of card use. What do we use it for? We use it in credit card fraud prevention. Now, this example is actually not great because of very low contrast. So because of this low contrast between the background and the font, it's very hard to see. And when you actually look at it in a privacy policy, we zoom this in a little bit so it'd be easier to see. But when you look at this in a privacy policy, the font is really small, the contrast is really low, so it's very hard to read for people. And this is true for anybody, right? It's hard to read for people with disabilities, but it's also hard to read for anyone else as well. You don't want people to have to strain their eyes, zoom in and zoom out, and go through all of this to see their privacy information. And that's why not just the way you display the privacy policy link is important, but the way that your privacy policy itself, the text appears on your website, is very important as well.
So a lot of people have questions around cookie consent banners and, who needs one in the first place. So I think we did discuss earlier that cookie consent banners required under the e-privacy directive, GDPR, which protects residents of the EU, the UK Data Protection Act, Canada's PIPEDA, California's CPRA, and Virginia's VCDPA. And a cookie consent banner is a mechanism that allows websites to respect your users' privacy rights by requiring their consent to be provided prior to the application of certain cookies being placed on the user's browser. And really what this means is if you have, let's say, Hotjar analytics, Hotjar is an excellent example where you're understanding how people use your website. And there's absolutely nothing wrong with that. But what's important to remind yourself of is that privacy laws protect and regulate the ability to just willy-nilly do that. Rather, you have to get consent first before you can allow Hotjar to operate and start analyzing visitors visiting your website. And that's the e-privacy directive, GDPR, and the UK Data Protection Act, and PIPEDA. However, CPRA has a modified cookie consent banner, as well as VCDPA, where it is an opt-out of sale of information.
And to actually obtain consent, so consent is also a legal term, right? So to actually obtain consent, the user must be presented with an accept and a decline option. So that means that you have to have an option that says accept and an option that says decline, and they both have to be equally prominent. Now, inactivity, meaning doing nothing, does not actually constitute consent. So all of the cookie consent banners that just say okay, or by using this website, we assume that you're okay with cookies, that is not actually proper consent, and that is a violation of these laws.
And there's companies that have been dinged eight figures, if I'm not mistaken.
That's right. Yep. So we'll show you some examples here as well. But what's important here to remember, cookie consent banners must control all non-essential cookies to not fire until the user provides their consent. Now, essential cookies, which are essential to the operation of the website, meaning that without these cookies, the website would break, those do not need consent. However, any marketing or functional cookies or advertising cookies, they cannot fire until the user provides their actual consent. So how to display your cookie consent banner. So here we have a cookie consent banner that says privacy settings. We use third-party website tracking technologies to provide and continually improve your experience on our website. You can revoke or change your consent at any time. It links to a privacy policy. It also links to more information, which leads to a cookie policy. And then it has toggle tabs. So one tag is marketing, which is turned off. Another tag is functional, which is turned off. And another tag is essential, which is always turned on per regulations. So here you can make a choice. You can accept all, meaning that you accept all cookies. You can toggle marketing or functional. So let's say I only want functional, I can turn that on. I only want marketing, I can turn that on. You can click deny, which means that no cookies will be turned on except essential. And then you can also save your settings. Now, what's important to note here is that accept all and deny both have the same prominence. So they are both large purple buttons of the same color with the text being in white. And that's very important because you're not tricking the user into agreeing. So if you had accept all in green and deny in white, let's say, that would be considered a dark pattern because it tricks the user into consenting, which is not actual real consent. And then on the right, we have a purple fingerprint icon. So what happens with cookies is that users have the right to consent to cookies, and they also have the right to withdraw their consent. So let's say yesterday I agreed to a Facebook pixel to track me. Let's say today I decide, no, I actually don't want that. I have the right to go in and change my settings. So what I do here with this particular cookie consent banner is I will click on the fingerprint icon, and then I can unselect or reselect any cookies that I want and change my options at any time.
Now, how not to display your cookie consent banner, and hopefully everyone's finding this interesting. I'll let you know, like, once you learn this, it kind of becomes interesting going to websites and being like, oh, you're not compliant.
It is fun. If you are ever bored or have a hard time falling asleep, check out Dark Patterns Hall of Shame. So that's actually a website that aggregates all of these violations and kind of shames companies. And there's also really interesting e-commerce dark patterns, which I love looking at, of how people trick people into making a purchase.
Well, and sure enough, with this example we have listed here, we have what looks to be a pretty big consent banner saying we care about your privacy and going on
Do
to
you
describe
though?
it.
Do you?
Yeah, no kidding. And then we and partners process data to provide, and they list a bunch of purposes as why they process data. But the problem here is that we have a big blue I accept button that's it quickly captures your attention. You want to just click it almost right out the gate. And then there's show purposes is an underlined hyperlink with a white background and just the word show purposes in blue. So it's very clearly drawing your attention to an I accept button. But as we just learned, you need to have a clear deny option as well. You got to remember, certain privacy laws allow people to not be tracked by default, meaning they have to consent to your website first before you're allowed to start tracking them or placing non-essential cookies on their browsers. So this is a deceptive cookie consent banner because they're trying to encourage you to forfeit your privacy rights by clicking that blue I accept button.
Yeah, and there's no deny button. It's only show purposes, which is not deny. Show purposes is show me a list of why you need these cookies, not actually deny them. So this is a perfect example of a non-compliant banner.
Here we have another example of how not to display your cookie consent banner, and the previous example is bad. This one's even worse, in the sense that, man, this screenshot is of a giant accept button. It says we need your consent to set cookies on your device. To agree, click accept below. And the accept button takes up like 30% of the bottom half of this thing. And then in the bottom left corner is a tiny little reject button, and then a more information button in the bottom right corner. So this is very clear that the company is trying to encourage you to forfeit your privacy rights in exchange for them being able to track you and so forth. And this is the type of dark patterns that have gotten companies fined significantly.
Yeah, and there's another two problems here. So again, we blew up this screenshot so that it'd be easier to see. But in real life, the reject button was tiny, right? So it's definitely not accessible because the font was not large enough. And the problem here too is we need your consent to set cookies on your device. Do you mean you would like your consent? Right? It's almost like making you feel like you have to consent when in reality you really don't. So there's problems with the verbiage and also the way that this is set up as well. This one is one of my favorites. So this one makes it essentially impossible for a user to figure out whether cookies are actually turned off or on. So you have measured ad performance, measure content performance, apply market research, develop and improve products, store and or access information on a device. And at the top, there's on in white and off in gray.
In the right-hand column.
In the right-hand column, yes. But if you actually click on, then on becomes blue and then off becomes white. So it's very unclear as to what selection I have actually made because the colors flip-flop. So on one side, on is in white, in the other, it's blue. So is it actually on? Is it actually off? It's very unclear as to how to actually figure out what is going on here. So I think that would be a really big issue, both from a privacy perspective, because you can't understand what's turned on or off, and then also from an accessibility perspective as well. Now, this one is actually a great one as well. It says, we use cookies to offer you a better browsing experience, analyze site traffic, and personalize content and serve targeted ads. By continuing to browse the website, you will continue to our use of cookies, and then you click continue to browse. So this actually does not obtain any consent whatsoever, meaning that this is not sufficient to establish consent under privacy laws because non-activity is not sufficient to establish consent. So these types of banners definitely need to go. We call them placebo banners because they don't allow user any actual choice, and the cookies are applied to their device regardless of what they actually choose here.
Yeah, and for anyone who's thinking, I just don't want to comply with privacy laws, well, just don't even have these fake banners. Like, just bring people. I mean, if you're going to track them, you're going to track them. Like, I mean, you don't even need a banner then.
This helps no one.
Yeah.
Now, keeping accessibility in mind with your cookie consent banner, Hans, you want to take this one?
Yeah, absolutely. So when you, for this example, this website, for example, when you click tab, the very first thing that happens on the website is you're brought right into the consent mechanism. And that's very common because you want to understand people's consent choices prior to them interacting with the rest of your website. This is very common if you have like analytics tools on your website where you want to get consent sooner than later so that you can understand how do people interact with your website. And I always say there's nothing wrong with collecting analytics data or sending targeted advertisements. I love targeted advertisements personally. I know you hate them, but I love them. I love them when they're relevant to me. So, but what I like as a person is the ability to choose who sends me targeted ads. But as you tab through these options, you're brought to each and every section so that you get a choice whether you are navigating with a mouse or a screen reader. You can choose marketing or functional cookies. You can choose to enable or disable them. You can access the privacy policy or more information which are underlined. And then you have the clear save settings, deny button, and accept all button. And last but not least, you have the ability just to close out in the top right corner. So being able to navigate a consent banner is just as essential as ensuring you're getting consent in the first place, because it all comes back to wanting to ensure people have access to your website and they have the ability to set their privacy preferences when visiting your website.
And most cookie consent providers will state on their website whether or not they're accessibility compliant, so make sure to keep an eye out on that as well. So obtaining and withdrawing consent. So you need to get a consent to email marketing for many privacy laws, and many individuals have the right to withdraw that consent. So consent must be provided in a way that a consumer can say yes or no, and it must not be confusing and must be accessible. So here you'll have an email marketing subscription form, and the user must opt out if they do not want to receive messages instead of being allowed to opt in. So here it says, choose how we send you marketing messages. Tick the box if you don't want us to tell you about offers, rewards, and information about products or services. We'll never share your details with anyone else without your permission. Lie. But when it comes to privacy law compliance, most privacy laws, such as GDPR, do require email marketing to be opt-in. So you cannot opt in people by default. They must opt in themselves if they would like to. So you need to allow people to opt in and also allow them to opt out as well.
Yeah, this is one of the most confusing screenshots I've ever seen because it's the title, choosing how we send you marketing messages. So I think, oh, how do I want to receive marketing messages? I should click what I want to receive.
Right,
but then you read the second text and it's saying, click what you don't want us to tell you about. Like,
Yep.
oh,
So this is
every customer must be super upset with what they offer.
I would say that any reasonable consumer here would assume that if I tick the box, that's how I receive the messages. That's not how I receive. That's how I not receive messages. So it is confusing
Very
for sure.
confusing. And we do have to speed it up a little bit so we can get to Q&A to help people out. But here is an example of a very difficult to read screenshot where there's black font, and it's hard for me to see this currently, but there's messaging inside that is kind of hiding details with regard to how to unsubscribe from emails.
Right. So it says click here to unsubscribe. And I only know this because I zoomed into this and stared for like 10 minutes. But the here is underlined. It's basically, you cannot see it.
It's
Nobody
deceptive.
can see it. It's extremely deceptive. It's in violation of privacy laws and also in violation of accessibility laws, as the unsubscribe link is essentially invisible. So on your email marketing, make sure that click here to unsubscribe is very visible.
And just as an average consumer, I feel like when we
It's
see this,
frustrating.
and we see companies do this these days, and it just is like, oh, this company's shady.
Yeah.
Like I instantly lose credibility when you do these types of dark patterns.
Absolutely.
Here's another consent banner, which yet again has a giant confirm button to subscribe. Oh, sorry, this isn't a consent banner. This is the option to subscribe to a newsletter, where you have this giant green or red confirm button with white text. And then you have this tiny little no button, probably a button, but it looks like just behind this black background, it just says in red small text the word no. And yet again, this is encouraging customers to have their data be sent off to another vendor. And granted, this company probably shares data with their email marketing provider like MailChimp or Constant Contact. They're going to send the email to that third-party company. And that is yet again a deceptive practice.
Right, because the confirm is so visible in red and the no is so small and so invisible that people will automatically click confirm. Here's an e-commerce form. So on the left side, you'll see basket, vehicle check, $14.99. And at the bottom, there's a pre-ticked box that says I've read and understood to the terms and conditions. And then it says more info. So actually, if you click more info here, you'll see by submitting your details and your consent, you will get email newsletters from the company and also from their quote unquote carefully selected partners. So I have read and understood the terms and conditions. That is no notice to the individual that this is actually affecting their privacy. Both of these boxes are pre-checked. All of the information is hidden to somewhere where a user wouldn't normally click. So it's not compliant with privacy laws, as it tricks people into not reading the relevant privacy information, and also has a pre-check consent box.
And we have 8 slides to go. I think we should average about 30 seconds a slide so that we can get a little Q&A going on here. So yeah, go ahead.
A dark pattern, which is what we've been showing you, is a user interface that has been crafted to trick users into taking or not taking certain actions. And here's another example. So let's get you connected. So to get 500 megabytes to use over the next 7 days, at hotspots, you can register again in 7 days. So it has a box and says, yes, I want to receive offers and promotions. I can unsubscribe at any time. But what's interesting about this is that you are required to subscribe to receive email marketing and promotions from this company and everybody else to actually connect to this. That is not necessary, right? And it's not necessary to share your data with other people to be able to receive the service. So don't preface consent with a requirement. Don't force people to consent. Make it an actual choice.
Yep.
Here, so wait, don't go yet. Use $20 off your $40 styling fee. You enter your email address and click get started. And at the bottom, it says, no, thanks, I don't want to look my best. So they're basically shaming you and saying that you would rather be ugly and wear hideous clothes than, give something up as easy as your email address. It has no privacy information. It's likely used for marketing, shared with third parties, or even sold. And this no thanks, I don't want to look my best. It also does not meet accessibility standards, as the no thanks font is too small.
And also,
well, thank you very much. We're out of time. We have about, unfortunately our time is up at 6:50. We probably have time for one of the questions if we can hit that real quick. But if you can look at the questions before you leave and then maybe answer them in the chat area or something like that. Are your slides going to be available?
Yep. Yeah. And so we had 3 more dark pattern examples, but then the final one, we have 4 tips that I think are really good takeaways. So I'd love for we can add a link into the chat here so that everyone can read the tips at their own time here. And so you would like, Laura, you would like us to pick a question?
No, I was going through them.
Oh, okay.
Can we, Anonymous asks, can we use a global legal policies footer link to a mini sitemap page of all policies for sites that have many? I've seen this before on sites with 6+ policies. They clearly needed legally, but wasn't sure that was acceptable.
Okay, so as I understand that, basically this individual has a ton of websites, and can I standardize my policies by explaining in one policy and have it represent multiple sites? So technically it's possible, but every single website needs to be collecting the exact same personal information, sharing it with the same parties, and so forth. So if they are all basically mirror copy websites, having the exact same functionality, collecting the same exact personal information and sharing it with the exact same parties, and has all the same privacy practices, then yes, you can do it. However, that tends to be very rare, and it could create customer confusion. So I would say the high level answer, so long as it doesn't create customer confusion, then yes, it is possible.
But any link to the policy should include the word privacy. So if you have like policies, at least put privacy in like parentheses or something like that.
Well, thank you so much. This is one of those things that legal stuff, it scares me. So you guys make it a little bit easier, and I appreciate that. Like I said, we can continue the conversation in the chat or on social media using hashtag WPA11Y DAY and hashtag WPAD2023. We also would appreciate if you go to 2023.wpaccessibility.day /feedback to provide anonymous feedback for our speakers on their presentation and can enter to win a t-shirt while you're there. Stay tuned for alt text in the age of automation. How's it actually going? Coming up next with Caroline at 2300 UTC, 7 p.m. Eastern, 6 p.m. Central. And while you're waiting, don't forget to visit our sponsors page to grab virtual swag and enter for a chance to win great prizes. We'll see you back here in a few. Thank you.
Thank you to WordPress Accessibility Day 2023 sponsors. Platinum sponsor, Equalize Digital. Equalize Digital's Accessibility Checker plugin is an automated accessibility scanning tool that helps WordPress websites become and stay accessible. Platinum sponsor, Gravity Forms. Gravity Forms is the professional form builder that you need to create beautiful, powerful, and accessible forms. Gold sponsors, 20i, DQ, Empire Caption Solutions, Pressable, and WP Engine. Silver sponsors, Code Geek, Drake Cooper, GoDaddy, Lone Rock Point, NerdPress, Overnight Website by Kinetic Iris, Riola Networks, A11Y Collective, and The Blogsmith. Bronze sponsors, Accessicart, Green Geeks Web Hosting, Hall Analysis SEO Consulting, HDC, ITX, IvyCat, MetaBox, Pixel Chefs, Simply Schedule Appointments, SiteGround, Termageddon, Underrepresented in Tech, Weglot, and Yoast.